Okay, it is Thursday, November the 5th. That's right, Thursday, November the 5th. And this is the lecture for week 6. Week 6 lecture. And you know the reason why this lecture is taking place on today is because of the fact that the course ends Tuesday. So I will be going through catching up. I'll be working tomorrow pretty heavily trying to catch up is on weeks 3 for sure, and possibly start on week 4, but I got a procedure I got to do Saturday, so at the hospital, so I'll probably not get much done until Sunday after that. But anyway, there's been a lot of challenges I've had to deal with from dealing with my wife's issue, and then I had some issues myself, so it's been a challenge. So all of us have challenges, but you know my motto, adversity is a springboard to success. Just keep on trekking on. So let's share in the screen. Here we go. Week 6, the death penalty. So you're going to write about the death penalty and describe if the death penalty fits into the Constitution, and answer if it's fair, do you think, under the law. Describe the current state of the death penalty in your state, and explain if you disagree with the death penalty and why or why not. And then we're going to have your final course project. Remember this, that you're going to not have to worry about the interview. Do not worry about that. It's optional, okay? You see that in there. So you will not lose points for that. So basically what you'll do is you'll get those 20 points automatically by just making sure that you satisfy all these other requirements. So this is giving you a head start, and the reason for that is because now if you did do an interview with a local law professional, which most of you didn't, for week 5, well, I don't know that yet, but when we talked about this during the lecture, everybody decided that they were not going to do that. They were going to do the alternate assignment, which is fantastic. And then remember, it's APA. And as you can see, as I put in here previously, the week 6 lecture will take place today, the 5th of November. And then I'll have the link in here after that. Oh, okay. If you did an interview, that's great. I'm glad. I think then were you the one that said that they had a family member who was you were going to interview? Was that you, Cynthia? Was that you that had a family member that was in the field, or no? Yeah. Okay. I thought so. Yeah, I know with one of my students, only one. So you were that student that said that they would do that because of that, and that's fine. And actually, the reason we did it, I explained it in week 5's lecture, is because of the pandemic and the challenges that people would have for lining up someone with this pandemic. So no, no, you do not. If you for week 5, you do the one that you did. No, because it says in there, if you remember, the alt, and actually don't worry about the point system because it works out. It's to be the same thing for the rubric, so don't worry about that. So you're pretty straight with that. But it did tell you in week 5, if you looked at week 5, since you're talking about that, if you looked at the assignments, for week 5. The a one-page report outlining the interview, so forth. Try to get a resume, attach it, and then course citations in the body. Now, since it's an interview, you don't have to have references. You do not have to have references unless you include some additional information based on research. Then of course you would. But with the interview, you just have to provide the appropriate citations. I'm sure you know the method to utilize for citing an interviewer, right? You know that, don't you? Well, citing an interviewer, if you look at it, it's in there in the APA. Basically, what you do is you say the name of the party. Yeah, but you can look it up. You'll see it. It's pretty straightforward there. It's in there. It's in there because we use it all the time. All right. So anyway, so the answer to your question is no, that you don't have to do that. All right. So now let's go to the, well, you don't have, oh yeah, you do. It is in here. I thought it would show up. Before we do the announcement, let's go to the course calendar one last time. Okay, so let's move this up here. There we go. So you see, this is where we, a little higher, there we go. This is where we are now. Your, well, okay, this doesn't apply because this was for week 5. Notice your week 6 assignments are due the 10th. Your initial post, your reply post, your written assignment on the death penalty, and then the constitutional law, fourth, letting you know that the course ends. But you want to make sure that you have everything in. You have your final exam. So you have your final course project. You have the death penalty, written assignment. You have the final exam, again, as I said. And then your live classroom that I give you tonight. And that's it, okay? But it's due on the 10th, which is Tuesday, next Tuesday. All right, so now let's go over and let's take a look at the module, Crime and Punishment. And let's look at the assignments in detail. So you already know about this, to incorporate any feedback, which you don't really have to worry about that because most of you decided to do the information that's based on what you already have. So I already commented about your Fourth Amendment topic. Choose your opinion on the case law in the area and relevant cases, and then include recent related case, which you did that already. And then your interview, again, if you did it. If you didn't, don't worry about that. And then 6 to 8 pages. 6 to 8 pages. Okay. And that should be easy for you to do because you've already used it. Remember the cases that you briefed. Those briefs don't count as pages, but you can have them as addendums into it also as well. So, yeah. Do you guys hear a dog barking? Do you hear, can you guys hear a dog barking? Okay, I do. It's our dog upstairs, but because I have it on headset, you really can't hear it. We got a golden noodle, and he's spoiled. He wants to get out of his cage, my daughter's dog. But anyway, I just wanted to make sure you couldn't hear him. I didn't think you could. If I was upstairs, you would hear me, but I'm downstairs in my office. So anyway, any questions about the project based on what I shared with you earlier? Any questions? Any questions, Joffrey? Okay. Make sure it's double spaced, by the way, not single spaced. Okay, and then you know it's APA because it says that anyway, but you knew that already. Um, the written assignment, we talked about that already. It's a 1 to 2 page paper, and dealing with the death penalty. And I'm gonna talk about that in a few minutes. So I'll give you some information that'll help you deal with that. So you're gonna deal with each of these bullet points, and of course it's APA as well. Okay, 1 to 2 page papers. Make sure that you run your papers through Grammarly. Not too many of you have been caught with that, because it's very important, because I want to see your critical thinking. And then your discussion on DNA evidence, and you're going to deal with 2 cases, and you'll see whether you get the information for that, and you're going to review these cases. So as I said, your initial post is due Tuesday, and your reply post is due Tuesday. And then, of course, your final exam. This is a comprehensive exam going back to the beginning, and you'll have one opportunity to complete this exam. Okay, 19 multiple choice and 6 short answer questions. I will be grading those short answer questions. Make them as detailed as you possibly can. Very important. Okay, and then your live classroom lecture point there. Okay, so those are your assignments for next week that are due. Any questions about any of these assignments? I know you already talked about, you told me, okay, anything about the death penalty is pretty clear. Okay, now, one of the things that we'll do now is go and we will look at the content. All right, so I'm going to deal with cruel and unusual punishment. We've already talked about this, and this. So what you should be aware of, first of all, is that the death penalty, whether or not the death penalty is legal or not, it falls within the realm of the 8th Amendment, cruel and unusual punishment. And if you click on this, it gives you the actual amendment. And there it is. It should be in here. Oh, here it is. Yeah. The 8th Amendment reads, excessive bail shall not be required, nor excessive fines imposed, nor cruel, unusual punishments inflicted. So the point that I'm going to bring to you is that the question that I'm going to ask you off the top of your head, is the death penalty a violation of the 8th Amendment, or is it cruel and unusual punishment? Yes or no? Not your personal opinion, but legally. Cynthia says yes. What about you, Joffrey? Okay. What state do you live in, Joffrey? I think I know. Aren't you in Illinois? And Cynthia, what state are you in? Missouri. I don't know about Missouri, but I do know about Illinois. First of all, let me explain something to you. There's a famous case. Yes. There's a famous case called Furman, Furman versus Georgia. I want you to be aware of that case. And it is important for you to be aware of what the United States Supreme Court said about the death penalty. And that is 408 U.S. 238, and it was a 1972 case. And in that case, you could look at it. You'll see what I'm talking about. The United States Supreme Court invalidated all death penalty schemes in a 5-4 decision, with each member writing a separate opinion. Now, what happened, though, is that basically the Supreme Court in that case said that it was a violation. Now, did it do away with the death penalty? In fact, what happened is that the court would clarify that ruling in a later case in 1976, putting the death penalty back on the books under different circumstances. Okay? And so you want to make sure that you're aware of the fact that actually, I think that was Greg. Yeah. Greg versus Georgia. And that citation is, give it to you in a second here. Greg versus Georgia. All right, Richard Wright, where's that citation? You have it here. 1976. Trying to find it for you here. I know that it is, I have it in here. What happened? It's not in my notes here. Thought I had it. Greg versus Georgia. Here we go. Greg versus Georgia, 1976. 428 U.S. 153. Check it out. So what happened is that in the Furman versus Georgia case, and so what happened is that in the Gregg case, they said that under certain circumstances, the death penalty could come back. So therefore, what happened is that dealing with cases like Miller versus Alabama, where can a person under 14 years of age be sentenced to life without parole for the offense of murder, or does such a sentence violate the 8th Amendment to the Constitution? What they did earlier than that, before they start dealing with the 8th Amendment and getting off of the death penalty, they said that the death penalty in Gregg basically, excuse me, allowed the death penalty to be constitutional However, it is now handled under what we call a bifurcated hearing. And each state is allowed to determine whether or not they have the death penalty and how it operates. Illinois had a death penalty up until 2000 and I think 12. In fact, give me a second while I look this up. Okay. Illinois. Let's see. Okay, here we go. Illinois death penalty was repealed in 2011 in Illinois. And since that time, we have not had the death penalty. Now, the reason why the death penalty was abolished is, first of all, one of our governors, George Ryan, found that there were too many people who were on death row who were discovered to have been wrongfully convicted. And so when he got in a situation and ran into a problem, well, actually it was Blagojevich, the governor, got in trouble. Illinois Governor Pat Quinn, who I know very well. Pat Quinn was one of I mentored Pat Quinn at Northwestern Law School. He graduated in the class of 80. I graduated in the class of 78. So I was one of the seniors who was assigned to be his mentor. So Governor Quinn abolished the death penalty more than a decade after the state imposed the moratorium that was under Ryan, concerned that innocent people were being executed and wrongfully convicted. So it was March 9th, 2011. And there are many states, 25 to be exact, that still have the death penalty on their books. However, though, the death penalty itself is not a violation of the Eighth Amendment since Gregg. It was determined under Furman versus Georgia. So you should be aware. I think I saw that. Let me see. Your daughter was on the Lisa Montgomery jury. That was a death penalty case. She actually received her death date. Okay, I don't know about the Lisa Montgomery case, but I'm going to I'm going to open up your mic. Open up. Okay. Do you have your mic open now?
Yeah, now
okay.
I do.
Okay. So tell me about what you know about that Lisa Montgomery case. That's a Missouri case, right?
Yes.
Okay, so what happened?
She was a woman that attacked Bobby Joe Stinnett and cut her open and stole her baby from her.
Oh, okay. Wait a minute. I thought we had that happen here in Illinois. Oh no, we had one like that in Illinois. Okay.
Yeah.
That happened with Sean Gale, one of the Chicago Bear players. But go ahead. What happened?
Well, she stole the baby, but Bobby Joe Stinnett, the mother of the baby, died. Mm-hmm. And Lisa Montgomery was convicted. Well, actually, she did not claim that she was innocent. She had to own up to it. There was no denying that she did it. She was found with the baby, but
so she pled guilty.
She pled guilty by reason of insanity.
Okay, that was her defense. Now,
yes.
It sounds to me like was she found not guilty by reason of insanity?
No, she was found guilty.
Okay, and given the death penalty.
Given the death penalty. And just
Okay.
this last month, I believe in October, she just received her death date, which is December 16th,
Oh, okay. Now, what year was this said that this happened?
2008.
I was just gonna say,
2008 was the
I was,
trial. The incident happened in 2004.
okay, but she was sentenced in 2008 to the death penalty. And
Yes.
so now she, 12 years later, right? Now,
Yes.
and that my point that I was going to make is that many people who are on death row stay on there a long time before they actually do get, and it's an average of 8 to 10 years. And
Yeah.
so her date is coming up, and then you know what's going to happen there is that they're going to seek to probably appeal the case even
And
further, and maybe
yeah, gonna stay
and with a stay. What's her date?
December 16th.
So it's about a little over a month and a half from now.
Correct.
Yeah. So okay, very good. All right, I'm gonna close your mic again
Okay.
or close it off. But those are the kinds of things that happen with the death penalty. People should be aware of that. It's a long time, and the reason why is because what happened in the Gregg case set out certain procedures that you have what we call a bifurcated hearing. First, you're found guilty or plead guilty, and then the jury or the judge, depending upon the jurisdiction, um, participate in voting whether or not the individual should receive the death penalty. And sounds like in your state, Cynthia, that the jury, um, yeah, that the jury voted because of the heinous offense. Uh, that is just like a case that happened here in Illinois involving a former Bear football player, Sean Gale. And but here in Illinois, we don't have a death penalty anymore. You can only get natural life. And so anyway, that's a little bit about that. So dealing with the Eighth Amendment of the Constitution, and the initial question I asked you guys was kind of a trick question because the answer as to whether or not it violates the Eighth Amendment um, was changed from 4 years later with Gregg, and I gave you both cases so you can take a look at those. And but Furman versus Georgia, between that 4 year period, there were no more executions. Um, and so what they had decided, though, is that the death penalty is given in a humane fashion, such as if a person is sick, they won't execute them. They also give them a last meal. And then, like I said, there are so many um, um, attempts that is, yep, yeah, the executions have changed since the Manson, and now, like for example, they used to do hanging a long time ago, and then they went to the electric chair, and now most executions are done by lethal injection. That's how most of them are done. And so anyway, the point of the matter is they wanted to keep it as humane as possible. So you should realize that there were two cases, though, that came about that the Supreme Court dealt with that demonstrated how adults were treated differently. And so as a result, in a landmark case called Roper versus Simmons, 543 U.S. 551 205, the court made it clear that you can't execute minors. And in 2010, in Graham versus Florida, the Supreme Court ruled that it is a violation to sentence a minor to life without parole for crimes other than murder. So there's a difference in how the Eighth Amendment is applied when it comes to juveniles as opposed to adults. So that's just something you should be aware. And the reason is because we want to, if you look at the juvenile justice system, which we studied in the Introduction to Corrections course, that the goal is to try to salvage that young person as opposed to giving up on them. And so, as it says here, giving them a chance of rehabilitation. But there's still a lot of individuals. You keep hearing about wrongful convictions, about people being sentenced to many years in prison, and then they're exonerated after spending 20, 30 years in prison. So there's always going to be some issues with the death penalty. But in Illinois, there is none, as I said earlier, since 2011. All right. Now let's talk about DNA evidence. Let me tell you guys something. One of the most revolutionary changes in criminal justice is DNA evidence and how people were exonerated. I never had an opportunity to really use DNA because it wasn't as big when I first started. It didn't exist when I started out in '78. But since that time, it has been used to exonerate many people facing the death penalty or life sentences. My alma mater, Northwestern University School of Law, have a wrongful conviction project that they have done and is now internationally known for that, which started out as Northwestern University's legal clinic, which I was a part of when I was in law school. But one of the first cases that they had was a young man by the name of Rolando Cruz, who was charged with murdering a young girl in the Wheaton area of Chicago, a suburb of Chicago, and Janine Jacarico, that was her name. And he was actually tried and sentenced. However, Northwestern University took the case, did research, and it was discovered by the evidence of DNA that he didn't do it, but instead a guy by the name of Brian Dugan, Dugan, who was already incarcerated for something else, they matched up the DNA from her, and it matched up to him perfectly. And so he was exonerated. And since that time, Northwestern has gone on to use DNA evidence. And there are wrongful conviction cases all over the country. A young man I know who is now a lawyer was wrongfully convicted of raping a white female. He's African American in Wisconsin, and his case was determined by DNA evidence that he didn't do it, and he was released. Well, he decided that he would become a lawyer, and now he operates a wrongful conviction program out in New York. That's where he is now a member of the bar. And he's written a number of articles about that as well. So DNA evidence has been able to solve many crimes, and also it helps individuals to match up, as you know, the ancestry DNA. But the key thing is that it has really been a very good source of for law enforcement as well as prosecutors and defense attorneys to use in criminal cases. So as your discussion forum this week dealing with DNA, you have these two cases, Juan Rivera, and you're going to take a look at these cases, and Jerry Hobbs, and you're going to look at these cases and see how DNA applied. I'm not going to go into the details because that's part of your assignment, but it tells you right here, Juan Rivera as a match in the case, but the prosecutors would not dismiss the charge against him, and he was convicted on 3 separate occasions. Finally, it was reversed, and the case all right, and Juan got to walk away a free man. So he was exonerated as not being the one who committed the crime. The other case, Jerry Hobbs, he sat in jail 5 years while the person who committed the crime was free. DNA exonerated him, but prosecutors would not dismiss the case right away. You will be surprised. There are many instances where the prosecution will not do that. To me, it's beyond me because of the fact, yeah, you're right. You got that right. It is pride. They don't want to come back and say I was wrong. But due to the public defender's office, Hobbs was released and the true killer was caught. Kind of like the same thing I told you about what happened here with Rolando Cruz here in Illinois. You can look that one up. His name is Rolando Cruz, and that was a case. So anyway, this case led the prosecutor's office to fire the lead prosecutor because of their position, and rightfully so. Rightfully so. So use those with your discussion forum. But I'm very excited about DNA as a tool. It's funny. We used it a couple of times as law enforcement officers when I was a police officer after I had left law school, 89 to 93, to actually identify bodies, things like that. So the final thing I want to talk about, excuse me, is the 14th Amendment. And it talks about, it says that states should not deprive people of the life or liberty without due process of law. And what that really means is that you should have an opportunity to face your accusers and be able to provide a defense. And that's the first part. And then the second part of it deals with equal protection under the law. We talked about that already in a previous discussion forum, saying that all people should be treated equally under the law and enjoy the same protection. So I'm not going to elaborate on that because we did cover that in detail a few weeks ago. But it is so important that people understand that the Fourth Amendment search and seizure was applied to the states by the 14th Amendment because it said that states should not violate the constitutional rights of those individuals for the Fourth Amendment. And so due process, back to it, is so important because of the fact that you have to make sure that there's willingness in your pleading guilty. A defendant pleads guilty to burglary and the criminal damage to property is dismissed as part of the plea. A year later, the prosecutor charges the defendant with the same crime that was dismissed. Under the laws of due process, the state cannot re-prosecute this case. Not only the laws of due process, but what other reason could a person be tried a second time? In many cases, but didn't apply here. Yeah, double jeopardy. But this was not double jeopardy because since the previous case was dismissed. So when you dismiss the case, then that don't mean you can't come back later and re-prosecute them. If you prosecute a person and then they're found not to be guilty, and then you come back and try to re-prosecute them, then that's double jeopardy. So that's why the example that they gave here, under due process, the state cannot re-prosecute this person because the evidence would end up being the same evidence. Okay. Laws must be clear and not vague under the laws of due process. That's why there are certain statutes that are what we call void for vagueness. Did you ever hear that term before? Void for vagueness? I know you did. I was waiting for you to say yes, because I already know you learned in your paralegal program, right? Yep, I know. I know, because you have good people over there. I have really good friends of mine over there. Uh, People like Dan Walker. Did you have Dan Walker? Did you have um, Kirk Olsen? Yeah, he's pretty cool. By the way, Kirk is yeah, Kirk is a good friend of mine. He's going to be an adjunct professor starting in I think in January. He's leaving full time, but he'll still be around. Did you know that? Yeah, yeah, they kind of announced it. They kind of announced that. But anyway, the bottom line is that in that program, you learned about those kinds of things. So you understood how that works. That's fantastic. That's Lloyd. And what it really means for those of you who are not familiar with what that means, it means what it says. The statute needs to be clear enough so that when a person violates it, they can understand it. Okay, you should become a lawyer, Cynthia. You should become a lawyer. You'd be good at that. But then don't just would like to. 3 words. Just do it. You heard what I said. If you want to talk to me some more outside of class or reach out to me about discussing any further, feel free to reach out to me. I'll be happy to talk to you some more about that. Okay. All right. So anyway, so laws have to be clear to know that what you're violating. Now, some of the laws that were usually used to determine void for vagueness is attempts to try to control gangs, and they had these laws that said that people hanging out on the streets with a certain number were guilty of committing a crime or something, but they weren't doing anything wrong. And so those statutes were usually held to be unconstitutional. It's unconstitutional if it's a void for vagueness. It's under the laws of due process. It's because it is a violation of the Constitution and the 14th Amendment. Okay, and that's pretty much all I want to talk about for the night. Any questions? Okay. Well, I do want to say, um, before I give you the phrase that I want to give you, first I'm going to give you a shot at the phrase. Anybody have any ideas of a phrase? That's good, but that's not it. But that is a real good one. That's another good one. Any others? You don't know. How about due process? How about that? That's the last thing we talked about, but it's also overwhelming in terms of dealing with, so yep, due process. Give me due process and you get your points. So I want to say to each of you that this has been a quick, fast course, constitutional law. You've been very fortunate in this class that you've had me to talk about Supreme Court things that are happening to keep you focused on how the Constitution applies as far as Supreme Court. Remember, we started the first week talking about the lifetime appointments and how the Supreme Court is used. What's most interesting about this now, and I got to say this now, is I don't know if you're following the news or not, but the president is not happy with, yeah, yeah. the president is not happy with the way that the results are going in the counting, and because of the fact that the pandemic, there were a lot of early voting and a lot of mail-in votes because people didn't go out and vote on the day of election. I did, but a lot of people didn't. And so now the counts that appeared from the first day are changing. And so what I'm about to say is that one of the things that he said the other night, and his Republican colleagues are very upset with him. He says that he wants to take these cases, he wants to file suits and take it all the way to the United States Supreme Court. Now, you know, and I know why he said that. I mean, he just got his third appointment, Amy Coney Barrett, who, you know, he thinks that the Supreme Court will do what he tells them because he appointed them, but he doesn't get it. It doesn't work like that. Already, Justice Roberts, who shown, you know, he would not go along with everything that is said. But anyway, the point of the matter is this: you're learning that the Supreme Court is a powerful position, and also you learn about how the legislature operates with the House and the Senate, and you saw the battles between the Senate and dealing with the various hearings that take place with the impeachment, going back even with all of that stuff. All of this stuff is constitutional law, dealing with the rights of individuals to gather and protest peacefully, and how you know, people would try to use that loitering laws, as that's what I was talking about earlier, to try to control people, but most of those laws fall as void for vagueness. And so what does that mean if you're 12 people at the bus stop? It's a crowd there. But anyway, the bottom line is that they need more clarity. So anyway, in this course, we've dealt with those issues. We've dealt with the rights of individuals, specifically with the Fourth Amendment and the importance of proper search methods taking place under the Fourth Amendment, understanding the difference between reasonable suspicion and probable cause. These are things we dealt with in this course. Equal protection, and then we conclude here with the key phrase, due process. And so I enjoy this course, being a political science major, as well as being a person who practiced criminal defense law is my favorite area. And I was pretty good at it. I knew how to do all of those things pretty well. My not guilty determination before juries was in the high 90s. So I did pretty good communicate. So, but anyway, what I want to say to you is that you should always remember the importance of constitutional law. Just like we didn't spend a lot of time on the Second Amendment, but you know, the Second Amendment is here. I don't like the way people try to stretch the Second Amendment and use it. Like I just found out that people that showed up at the place where vote counting was taking place in, I believe it was Arizona, were out there with their Trump flags or whatever flags they had, waving them, and they had weapons. And I said, "This is what's that all about?" Well, that's because they could open carry, and so there are some problems with the Second Amendment in terms of the shootings that happens in the schools, the shooting that happened in Vegas, the shooting that happened out in California as well, and all across the country, the shooting that took place on the military base dealing with Sandy Hook, dealing with the one down in Texas. I can't remember the name of it off the top of my head now, but my cousin was down there when that Fort Hood, you know, those different things. So there's a whole myriad of things that you learn in this constitutional law course, and I wish they would have a part one and a part two, but we can continue some of the topics that we did in the first 5.5 weeks, and then have a second half. So we can elaborate some more on the First Amendment, so we can elaborate more on the Second Amendment, so that we can talk about more detail the Eighth Amendment and cruel and unusual punishment, so that we can talk about the Sixth Amendment, the right to counsel, speedy trial, and also uh, dealing with, as I said before, the Fourth Amendment, more details in terms of the importance of it. I could do a whole module on just the Miranda case, as I've shared with you some points there, very important. So, but anyway, guys, I just want to thank you. I appreciate you coming out, those who've come out consistently for the lectures. I also appreciate the fact that, um, you guys have been fair with me in terms of realizing the circumstances I've been battling. This has been a tough 5.5 weeks with the personal issues that I faced. As most recently, we did find out that my wife did have a heart attack, and she's only 56 years old. So that's tough. I'm, you know, watching over her now. So anyway, I had students in class that have had issues dealing with all kinds of things, from COVID-19 and their family members, losing family members, people actually being students that let me know that they were sick because of that, and just a whole lot of things. And then above all, it's not very easy. Online is good, but when you have to shelter in place as well, um, that's not good, because our natural way of life is to get out and enjoy. But now, like for example, here in Illinois, in our area here, they're closing down things again because the numbers. This COVID-19 is no joke, guys. It is killing people in astronomical numbers. It's not a political issue. And so it has, put a different spin on us as educators, you guys as students, my kids. One of them's at Rasmussen, um, but one of my kids is in sixth grade, and so she has been working from home. She hates it. I thought you like your computer. She's not into this stuff yet. They're on Zoom. That's how they do all their classes. They don't use WebEx. So anyway, guys, so again, it's been a pleasure. I hope I see many of you further down the road. If you need a referral, feel free to reach out to me, and I will deal with that. I just completed a referral for a former student of mine that I think I had her in 6 classes, and including this class. But I don't know if any of you are going to be taking, what classes are you guys taking next term? Any, you know what you're taking next term? In the criminal justice area. You know what you're taking, Cynthia? Or Joffrey, do you know? You don't know what your next courses are? They start next week. They start, the T2, term 2 starts next Wednesday. And you don't know what classes that you're going to be taking for term 2? Oh, no criminal justice classes. Okay. Contemporary leadership. Okay. Um, okay. What about you, Bob? What do you, Robert? What do you taking any criminal justice classes? Not saying anything. So, well, anyway, I will be teaching courses that you probably have already had or should have already had is Introduction to Corrections. No, I'm sorry, I won't be teaching that. I will be teaching Drugs and Crime and also Introduction to Criminal Law, as well as this course again that I'll be teaching. I think I mentioned that last week. So, oh, crime prevention. Okay, okay. So anyway, I wish you guys the best. Again, stay safe, and I'm still around if you need me after the course is over. So have a good one. You're welcome.